Before we jump into this courtroom moment, here's the situation. Rebecca Curtis is facing some serious criminal charges, including assault on a police officer, resisting arrest, and obstructing official business. But what makes this case explosive isn't just the charges. It's the tension between Curtis and the court system itself. As you're about to see, she openly accuses the system of treating her unfairly. The judge, however, is looking at a long criminal record and repeated violations of court orders. So the real question becomes, is this someone who's been failed by the system, or someone refusing to take responsibility? Watch closely, because what unfolds in this courtroom quickly turns dramatic.
You wrote the State of Ohio versus Rebecca Curtis. You are Rebecca Curtis?
Yes, sir.
Ms. Nicholson is here on behalf of the State of Ohio. Can you tell me when she's scheduled to be in front of grand jury?
Her indictment was issued this morning.
She was indicted this morning.
So I do have a copy of that. I can serve her with. It is for 2 counts of assault on a police officer, felonies of the 4th degree, the 1 count of obstructing official business, a felony of the 5th degree, a misdemeanor 1 resisting arrest, and a misdemeanor 4 criminal trespass.
Okay.
For the record, she has been handed a copy.
Thank you.
And Your Honor.
At this point in the hearing, the court formally presents the charges and begins discussing procedural steps like arraignment and bond. This might sound routine, but it's actually one of the most important parts of the early criminal process. Charges like assault on a police officer, even at the 4th degree felony level, carry serious consequences. When combined with charges like resisting arrest and obstructing official business, the situation becomes even more complicated. Judges must decide whether the defendant can be trusted to follow court orders while out of custody. That's why the court starts looking into Curtis's employment, living situation, and mental health history, all factors that determine whether someone is considered a risk of reoffending or failing to appear in court.
We do have an arraignment entry if the court wants to arraign her today.
No.
Or it's set for next week.
Yeah, she can just wait.
Okay.
Yeah, it's she was just served, so she's got 24 hours. She might as well just set it for next week. Ms. Curtis, it's somewhat unusual for me to schedule this for hearing. Since I did not set your bond, I did not revoke your bond. Usually I only set these for hearing if I revoked your bond from the lower court. Tell me why I should modify this bond.
Well, I'm just trying to be home for the holidays, really, if I can.
Officer, you have any information about this at all?
You're roped into the jail on the 25th. She'll have 25 days credit. I spoke with her over the phone yesterday and put all that information in the bond report. She provided a Middletown address. She reported she stays there a few days off and on, and then goes and stays at motels often. Reported she's not employed, that she's unable to get employment due to having cirrhosis and her mental health. And then she reported that she's currently in treatment with Butler Behavioral Health for PTSD, battered woman syndrome, human trafficking victim, but I was unable to verify that.
Got quite the record, Miss Curtis. Dating all the way back to 2008. I'm sorry. Goes on. I'm sorry. What keeps going on? 2002.
Now the judge brings up something that dramatically changes how the court views this case: Curtis's criminal history. According to the record, it stretches back more than 2 decades, which immediately raises concerns about whether she has a pattern of ignoring court orders. Prosecutors also mention past violations of supervision and treatment programs, which can make judges hesitant to reduce bond or grant release. But at the same time, the defense mentions serious personal struggles, including mental health issues, trauma, and unstable housing. Situations like this put courts in a difficult position, balancing public safety with the possibility of rehabilitation. And it raises an important question for viewers. Should courts prioritize strict accountability or focus more on treatment and recovery?
Who do you live with?
My daughter.
The state have a request for bond?
Your Honor, this occurred all 75 back in November. So I don't know if it appeared that she was living there at the time. You know, I know I read in her letter that it indicated that she was in treatment, but alarming that this set of facts occurs while she is in treatment. Additionally, she was sentenced to prison in January for an after an ILC violation, and was released about 4 months prior to this offense. She has a history of community control violations and not following orders given to her by the court. So I think if the court is inclined to release her, I mean, her bond is $100,000, 10%. If the court is inclined to modify that or to release her, we would ask that she be placed on electronically monitored house arrest. It sounds like she doesn't, I don't know how stable her living arrangements are. She does have a lengthy history.
Ms. Curtis, you were granted ILC by me in December of '24, so 1 year ago. Within a few weeks of that, you refused to go to the CBCF that I ordered. So I'm guessing you just wanted to continue to use the illegal drugs.
That's
then
your
I think-
assumption, but I can drop urine and it's clean. I go to.
Well, you've been in jail for the last 30 days. I certainly hope that you'll be clean.
Well, yes, but I'm saying prior to that, you can
Yeah.
discuss it about the behavior if you need to. I'm still going there.
Well, since you're going to be arraigned on Wednesday, at this point in time, the court's not going to modify the current bond order. I'll let the you can make a pitch to the magistrates when they arraign you next week. All right, that's all. Hey, deputy, bring her back in here. Deputy.
Yeah. What is it?
You have something you want to say to me?
Not you. No, sir.
You were in my courtroom. I
was walking away from your courtroom. Is what I was doing.
Ma'am?
I'm so tired of this system fucking me over. Is what I'm tired of doing. I really am, sir. It's not you directly. It's somebody else in this system. I
But when
appreciate you. I respect you. But I am not going to keep letting this shit happen to me. I'm not. And other people. It's not you. It's somebody else in this system. That's all I'm saying. No disrespect to you. Have a nice holiday.
I am disrespected because when you use that kind of language in my courtroom.
Well, when I get mistreated by the system, you'd feel the same way, sir.
All right.
No disrespect to you personally.
But it
It's
is.
somebody else. Thank you, sir. I have the freedom of speech, you know. Like I said, fuck 'em.
This is case number 25CR43210, the state of Ohio versus Rebecca Curtis. Ms. Curtis is before the court with her counsel, Mr. Washington. Ms. Nicholson, on behalf of the state of Ohio. The court is in receipt of the report from the Forensic Evaluation Center prepared by Dr. Nichting. The date of the evaluation, February 12th. The date of the report, February 17th, 2026. Has everyone received a copy and had an opportunity to review that report?
Yes, Your Honor.
Yes,
Do
Your
we have
Honor.
a stipulation to the report?
Yes, Your Honor.
We'll stipulate to the report.
All right, based upon that, the court will make a finding that the defendant is currently incompetent to stand trial, and based upon the report of Dr. Nichting, that
After everything we've seen unfold in this hearing, the court ultimately makes a critical decision based on a forensic psychological evaluation. The judge rules that Rebecca Curtis is currently incompetent to stand trial. Legally, That means she does not fully understand the charges against her or cannot assist in her own defense at this time. Because of that, the criminal proceedings must pause while she receives treatment designed to restore her competency. She'll be transferred to a behavioral health facility where professionals will work to stabilize her condition, so the case can continue later. Cases like this highlight the complicated intersection between criminal justice and mental health, showing how courts must balance accountability with medical evaluation. If you found this courtroom moment shocking, make sure to hit the like button, share your thoughts in the comments, and subscribe to the channel for more intense courtroom breakdowns and legal drama.
That she is restorable to competency within the statutory period. The least restrictive placement for the restoration is Summit Behavioral. Anything else?
Your Honor, I've prepared the entry and put in the language that earlier bed becomes available at Appalachian, she can be transferred there.
That's fine. Just watch it. Basically, if a bedded day becomes available at Appalachian Behavioral, we'll send her there to get it set up. I don't want her just sitting and doing nothing.
Okay.
So the restoration, it just speeds up the restoration process. That's all.
Okay. Thank you, Your
All
Honor.
right. Thank you, Mr. Washington.
Now what?
They're going to take you either to Summit or to the Appalachian place.